Associated Student Speakers Program. We are fortunate to have with us today two distinguished men who will be debating the timely and controversial topic, the need for abortion law reform. Again in 1967, Assemblyman Beilenson will present his bill that he is sponsoring. We are indeed fortunate to have with us today the sponsor of this bill, Assemblyman Beilenson. Mr. Beilenson, a graduate of Harvard Law School, was first elected to the state legislature in 1962 and was again re-elected in 1964. Assemblyman Beilenson's bill will of course be heavily debated. Among the more articulate opponents is our second guest today, Mr. Walter Trinkaus. Mr. Trinkaus, a practicing attorney here in Los Angeles, has appeared on a number of occasions before legislative committees and was also on the CBS Reports television program on abortion and the law. Immediately after the debate, there will be a brief intermission, and then all those who wish to remain for the question and answer period, would you please come forward, and we will continue with the question period. At this time, we shall hear from our first speaker, Assemblyman Anthony Beilenson.
Mr. Chairman, Mr. Trinkaus, ladies and gentlemen, thank you for your kind introduction. I'm here today to tell you that I hope you win the game Saturday, and that I don't think that a new football stadium should be built at your expense here on the campus. And now that you know that my heart is in the right place, I'm here to tell you about my Humane Abortion Act. Back in April, a little over 2 years ago of 1963, I introduced this bill, which is called the Humane Abortion Act. I introduced the bill basically for two reasons. The first was that none of my 119 colleagues up there in Sacramento in the state legislature would themselves introduce it. And I must say, parenthetically, that after I found out what happened to me after I did, I can't blame any one of them for not having done it themselves. Secondly, and more seriously, I learned something about the problem of abortions and its enormity, its effect on so many lives, and I thought that at the very least there should be some public discussion on the matter. And that by introducing the bill, we did make it a public issue. We did force it out into the open. It has since, really for the first time out here on the West Coast at least, been discussed in the press and on radio and on television. And the enormity of the problem is this great. Every year in the United States, it is estimated that more than 1 million women are aborted. It's believed that that's a conservative estimate. Nobody really knows, it's a guess, but even the opponents of a more liberalized abortion law really don't argue with that figure. Every year in California, probably 100,000 California women are aborted illegally. There may be 150,000, maybe 200,000, maybe only 50,000. But however many thousand there are involved, it's obviously a tremendous problem, involves a tremendous number of women and of lives. Every year it's believed, and this is really a guess, nobody really knows this figure, of course, but it's believed that somewhere between 5,000 and 10,000 women in the United States each year die because of illegal criminal abortions. In any case, whatever the true figures, obviously it's an immense and enormous problem. It's a much greater problem than I had ever realized when I first went up to Sacramento, and a much greater problem than most people who are not familiar with the subject could possibly realize. The law in California with respect to abortions is the same as the law throughout the rest of the United States, with the exception of 4 or 5 states and the District of Columbia. That law is a very stringent and a very restrictive law, and it provides basically as follows. Every abortion is criminal. Every abortion is illegal unless its performance is necessary to preserve the woman's life. And that means that if you're indicted or you're prosecuted, you must make the jury believe that the woman would have died in the course of her pregnancy or in the course of delivery or immediately thereafter for it to have been a legal, non-criminal, permissible abortion. Now, although 20 or 30 or even more so 40, 50, 100 years ago, many women with various health problems could not survive a pregnancy if it was brought through to full term, The vast majority of women can today be brought safely through a pregnancy in the sense that they will not die in the course of that pregnancy. As one example, let me give you a simple example. A young mother, happily married with 3 young children, lives with her husband. If she were to go to her doctor, she has a serious heart problem, she's a cardiac patient. If she were to go to her doctor and say, "Doctor, my husband and I, my happily married husband and I, with our 3 sweet, happy young children, we're thinking of having another child because we love children. How does that strike you?" The doctor would say, "Absolutely not. You have a serious health problem. You should not go through another pregnancy. There's no knowing what the results might be, but obviously they would be serious. You might be crippled and unable to take care of any of your then 4 children. Your lifespan might be shortened by some indeterminate number of years we can't really predict, but it might be 5 or 10 or 15 years, and a pregnancy is the last thing which you should undergo at this time." But if you change the premise and you have this sweet young happily married mother going to her doctor saying, "Doctor, I think I may be pregnant." The doctor runs tests on her and she is actually pregnant. Despite the probability of all these possible serious problems which I just mentioned and the possible grave consequences of them, she cannot legally be aborted because the doctor cannot say that she will die, that she cannot survive physically this pregnancy. And this possibility of or probability of survival is the only relevant criterion now in our abortion law. Well, I suppose I've been belaboring the point that it's almost never necessary anymore to abort a woman to save her life. And that means, of course, that almost without exception, every one of these 1 million or more abortions performed each year on American women are illegal criminal abortions. Almost without exception, the 100,000 California women who are aborted each year are illegally aborted and are potential felons or potential criminals. Now, for a number of reasons, I felt, after learning something about this problem when I first went up to Sacramento 2.5 years ago, I felt that the existing state of the law was barbaric and hypocritical and uncivilized, and I thought that it ought to be changed. That, of course, is the basic reason why I introduced this so-called Humane Abortion Act. Now, this bill, when it's enacted into law, as eventually it shall be, will do 2 general things. First of all, it would extend the indications for legal, permissible abortions into 3 new areas. First of all, we would allow an abortion where pregnancy results from an act of rape. Now, one might guess, if one were simply stopped in the street and asked, that if a girl or a woman were raped now, especially forcibly raped, that she would not have to go through with a pregnancy which resulted if she didn't want to. But as you now know, if you didn't 2-3 minutes ago, that's not true. The only relevant criterion is whether or not the abortion is necessary to preserve the woman's life. Now, I won't argue this problem of pregnancies resulting from rape with you. Either you feel one way about it or you feel another way. I happen to feel that the humanitarian point of view dictates that if a woman does not want to go through with such a pregnancy, that she shouldn't have to do so. On another level, however, if you want to try to be logical about it, and I'm not sure that you can do that and successfully exclude any emotion or humanitarian concerns you might have, we have laws, obviously, and as you well know, against rape. It's a felony. We're attempting to deter sexual aggressions and attacks upon females. And what in effect we're saying is, I'm sorry, sweetheart, we didn't want this to happen to you, but now that it has happened to you and the most awful possible consequences have occurred, that is, you become pregnant because of this attack, from this point on now, society withdraws its protection from you and you're on your own. I don't think this makes sense just in terms of logic as well as in terms of emotion. So we would allow abortions where pregnancy results from rape. We would allow, secondly, an abortion where pregnancy results from an act of incest. Incest in California, as in most states, is a crime. Again, I won't argue the humanitarian grounds. For me, they're self-evident. For some other people, they're not. Again, I think we're being illogical with our existing state of the law. The anti-incest laws, generally speaking, were promulgated in the first place to try to deter conceptions or offspring from certain close blood relationships. We made the act illegal, but the most awful consequence of the act, and actually the final consequences, which in the beginning we were trying to prevent from happening by making the act itself illegal, we're doing nothing about. So we'd allow a permissible legal abortion in cases where pregnancy results from a criminal act of incest. And thirdly, and finally, with respect to the extended indications for a permissible abortion, we would allow an abortion where continuation of the pregnancy would involve substantial risk to the mother's health or a substantial risk that the child would be born with a grave defect. For the first time, we'd be seeking to give some legal protection to the unborn child. I'm frank to say that I would hope that if this bill were the law at such a time, if we ever had another terrible problem, such as the thalidomide problem, which we had 3 or 4 years ago, which, as you well know, was a problem basically in Western Europe and West Germany, I would hope that this bill would apply in such a set of circumstances, horrible, tragic circumstances. I would expect in some instances that this bill, when it becomes law, would apply in cases, especially in epidemics of rubella or German measles, where the percentages are not terribly well known, but vary anywhere from 20 to 40%, that a mother who contracts German measles during the first trimester of her pregnancy will give birth to a seriously defective child, whether it be a defective heart or eye cataracts or a lack of hearing or some brain damage. I would hope that this bill would apply in 2 cases with respect to a possible defective offspring, which occurred to a personal friend of mine, a doctor, in cases where there is extensive X-ray treatment in the lower pelvic area of a woman during the early days of an undiagnosed pregnancy, where the chances are actually 100% in some instances that the baby, if born alive at all, will be born seriously deformed. This particular friend of ours, this doctor, had to bring within the last year 2 women through pregnancies in which he knew the offspring would be terribly deformed, if indeed alive at all. I don't believe that women should be forced to go through 9 months of a pregnancy with this awful knowledge in their hearts and in their minds. In both cases, in these particular instances, these babies were born hideously deformed and, I think, fortunately, not alive. With respect to the health of the mother, I would hope that our cardiac problem, which I mentioned earlier, of a sweet, nice young mother with a happy family, that she would not have to undergo a pregnancy which would seriously cripple her or might cut down on her lifespan, which would make her unable, perhaps, to take care of her happy family, which she already has. I would hope that when the bill becomes law, we could take care of some serious psychotic problems which cannot now be taken care of under the existing law. And to take an extreme case, and basically what we're talking about are extreme cases.
1 minute.
This is an actual case where after prior pregnancies, a woman became terribly psychotic and was committed to institutions for a year at a time. She's pregnant again for the 3rd time, and the prognosis is that either she will have to be in an institution for the remainder of her life, or at best just for another for a year. I don't think such a woman should be forced to go through with her pregnancy. The second general thing, I have to hurry up here, we're out of time. The second general thing which our proposed bill would do would be to provide by statute that which is informally done now by most hospitals, provision of a therapeutic abortion committee, whereby we have a procedure where you can seek out in advance approval for a proposed abortion, so that when it's finally performed by the doctors involved, that they won't be operating under a possible cloud of criminality. We provide for the membership of this therapeutic abortion committee of members of the hospital staff of various kinds of doctors, a majority vote of the board that the abortion can be properly performed under one of the grounds I've just mentioned. We require the consent of the women involved. We require the affidavits of 2 personal physicians of her own if it's some health problem of her own which she is contending is the reason for the proposed abortion. We require that the abortion be performed in a hospital by a qualified doctor. Thank you. We'll resume later. Thank you very much.
Friends, Mr. Chairman, and Mr. Beilenson. I think Mr. Beilenson took one unfair advantage of me when he voiced the hope that UCLA would win the football game this Saturday. because I went to law school at USC. Your chairman explained that I am an attorney, and one of the difficulties with attorneys is that they think like lawyers and talk like lawyers. And in fact, I have thought, and I am talking about Mr. Beilenson's proposed laws along the lines of a lawyer. But fortunately, my legal premise, is one upon which I think all of us can agree. And then we can decide whether I have constructed an argument properly on that premise. But the premise is the due process clause of the Constitution as embodied in the 14th Amendment. Now, I am prepared to state, and I have stated before, flatly and unequivocally, that the laws which have been proposed by Mr. Beilenson to liberalize abortion are unconstitutional under the 14th Amendment without question if a conceived but unborn child is a person entitled to constitutional protection. Consequently, it is my statement that the real issue for debate is whether or not a conceived but unborn child is a person entitled to the protection of the Constitution under the 14th Amendment. And as a matter of establishing the validity of my statement, I would ask you to apply the provisions of Mr. Beilenson's bill not to an unborn child, but to a newborn child. And if that bill were to be applied to a newborn child, I don't think anyone would disagree with the statement that the law would be unconstitutional in violation of the 14th Amendment. Therefore, the issue to be debated and to be considered is whether or not an unborn child is entitled to the protections which would be given a newborn child by law. Now, as further test of my proposition, can you imagine a law which would permit a newly born infant to be killed because it is a burden on the physical health of its mother? But that is what is provided for in this bill for a conceived but unborn child. Can you imagine a law which would permit the killing of a newly born child because it is a threat to the mental health of its mother, as broad as the term mental health can be in application? Of course not. But that is permitted under the bill as introduced by Mr. Beilenson for an existing but unborn child. And what if the child is physically or mentally handicapped? Would we take the life of a physically or mentally handicapped child who was actually born? Of course not. But we are permitted under Mr. Beilenson's bill to take the life of an unborn child because there is a 20 to 40% chance that that child might be physically or mentally handicapped. Now, suppose these real difficult cases, which fortunately are rare, where the child is the result of an act of rape. I mean, we have nothing but compassion for the mother in a situation of that kind. but apply the law. We're dealing now with human rights. Would we take the life of a newborn child because that child was the result of rape and was an embarrassment to its mother and to society? Of course not. But under Mr. Beilenson's bill, we are even permitted to take the life of an unborn child if that child resulted from statutory rape, which is not forcible rape, which would automatically permit an abortion for any unmarried girl under the age of 18. Now, that would demonstrate, I think, that Mr. Beilenson's bill can be attacked as violating the substantive aspect of the Due Process Clause. Now, the Due Process Clause forbids the taking of a life of a person without due process of law, and that means that the life cannot be taken unreasonably. And I suggest that it is being taken unreasonably if an unborn child is entitled to the protection of the Constitution. Now, the Due Process Clause has another aspect, and that is its procedural requirements. Procedurally, a life could not be taken of a person in secret hearings, but the hearings provided for in Mr. Beilenson's bill are absolutely secret before a committee of doctors appointed by the hospital. A life could not be taken under a protected life could not be taken under the Due Process Clause without having an advocate or guardian to represent the person whose life is being taken if that person is helpless. But the life of the unborn child under Mr. Beilenson's bill is being taken with no provision for an advocate or a guardian to protect the interests of that child at these secret hearings which are being held in the hospitals. Nor is there a right of appeal or any right of review provided for in Mr. Beilenson's bill. And the results of these secret hearings without representation of the child are final. The files are anonymous, so that there is no opportunity for any public authority to check to determine what had happened, whether the findings recited in the file are really correct and apply to the situation. So once again I say that Mr. Beilenson's bill is unquestionably in violation of the 14th Amendment procedurally if an unborn child is entitled to the protection of the Constitution. So that leads me to what I have said at the outset is the ultimate question for debate: whether or not a conceived but unborn child is entitled to constitutional protection. Is it a person under as the word is used in the 14th Amendment? Now, the law today and for many centuries has protected the rights of a conceived but unborn child in many respects. The law in California specifically recognizes an unborn child in Section 29 of the Civil Code as a person to protect its rights in the event of its subsequent birth. This is applied to protect it from for damages in the case it is injured prior to birth. It is something strange about a situation where you cannot injure an unborn child without having to answer for it. But you can kill that child with no recourse, which would be the results in Mr. Beilenson's bill. An unborn child is recognized as possessing inheritance rights, property rights. It is also recognized as being entitled in California to support from its parent. And in one case, a guardian was appointed for an unborn child to sue its own father for support prior to its birth. Now, I suggest that if an unborn child is entitled to any rights, if it is a person for any purpose, it is a person for the purpose of protecting its most basic right of all, the right to existence, the right to its life. And that is precisely what was held last year by the Supreme Court of New Jersey, where the court appointed a guardian for an unborn child to take whatever steps were necessary to compel that child's mother to submit to a blood transfusion contrary to her religious beliefs for the stated and specific reason of protecting the life of the unborn child. Consequently, the law has recognized and does recognize the right of the unborn child to life. And if an unborn child does have this right to life, that right is protected specifically by the provisions of the 14th Amendment, and the suggested measure would be unconstitutional. Now, the more we know about the embryo and the fetus biologically, the more human it becomes. There was a time, centuries past, when the only way you could tell for sure that a woman was pregnant was when there was movement. And so they had the test of quickening to determine a pregnancy. There was a time not too long ago when people didn't know what went on in the development of an unborn child. They didn't know whether something was to be added at some later date or what happened.
1 minute.
But now we know that from the time of conception, an unborn child has inherent in it all of the qualities of a fully developed human being. So not only legally, but biologically, an unborn child takes on a human quality. I think, actually, that all of us recognize that an unborn child has rights, even the sponsors of Mr. Beilenson's bill. There are, of a sort, some protections in that bill. They do provide for a hearing, inadequate though it may be. They do have some requirements and some standards which have to be met, inadequate though they may be, and vague and insubstantial though they may be. But nevertheless, some effort has been made to put restrictions on abortion. Why? Why are there any efforts to put restrictions on abortion? I suggest it is to protect the life of the unborn child. But once you have conceded that an unborn child is entitled to protection of its life, then you have conceded yourself directly into the provisions of the 14th Amendment. Thank you.
As with all issues, although a great many people feel terribly strongly about it, one way or the other, this issue is not a black and white one. The answers are not easy ones. And to be more correct, I think the answer varies from individual to individual. That's what's wrong with the opposition's arguments. That's what's wrong with Mr. Trinkaus's arguments. They make sense to him, but not to me. They're valid for him, but they are not valid for me. As a matter of fact, there are many more people for whom they are invalid than for whom they are valid. And it's about time that the rights and the beliefs of this majority were given some recognition in our law. In the last analysis, that's what this bill is all about. It's an attempt to restore a degree of freedom of choice and a degree of freedom of conscience to the many thousands of women who annually are confronted with this terrible dilemma and who now have no real choice other than to go through with a pregnancy or to have a criminal, illegal abortion. Now, there are generally three kinds of arguments which are given in opposition to the bill. Mr. Trinkaus spent most of his time, I guess, on legal arguments. In my opinion, without trying to be personal about it, I think that these are the least valid arguments against it. I think that the medical and the moral arguments hold more weight, at least with me, as a sympathetic human being who has troubles even with my own bill at times, because this, as I said, is not an easy subject. And if I may, since we're so cramped for time here. Let me read a short part of my own testimony to the Assembly Criminal Procedures Committee earlier this year when that committee favorably passed on this bill. Forgive me for doing this, please. With respect to the medical issues involved, I'm not, of course, an expert in the field. I defer to the testimony given you earlier by some most eminent physicians on behalf of the bill, and I recall your attention once more to the more than 1,000 physicians, 1,100 actually, including the deans of our greatest medical schools in California and the chairman of all of the maternal mortality committees of the California Medical Association, all of whom have endorsed this bill. I think it's fair to say that there is some difference of opinion among the medical fraternity with respect to this matter, but I think it is also fair to say that a most substantial and respectable segment of that community favors the bill. It's apparent that the present law is not only incompatible with the appropriate application of present medical knowledge, but does not operate effectively to prevent illegal abortions, criminally or self-induced. Under present law, no consideration is given to the health and adequacy of the human being, not only of the mother, but also of the child. This problem is, for the great majority of the people, primarily a medical and not a moral one. Doctors within fairly rigid standards, such as those set forth in this bill, should be allowed to treat people medically as they believe would be best for the woman, and they should not be forced to make medical decisions on the basis of non-medical considerations. Many doctors now refuse to abort a woman or even to discuss the problem, even though they believe, and many of their colleagues believe, that the woman should be aborted. I do not believe that doctors should have to operate furtively and as criminals when what they are doing is acceptable practice among reputable physicians and when what they are doing is acceptable and proper practice in their profession. Further, I think this bill encourages proper medical practice. It requires, for the first time, approval of a board of doctors of a proposed abortion, and it requires that any legal abortions be performed by a qualified physician in a licensed qualified California hospital. Under the existing law, where the only relevant criterion is preservation of the life, it's totally irrelevant who performs the abortion or where it's performed. If a carpenter performs an abortion in his workshop and he can make the jury believe the woman would have died had he not aborted her, it's a perfectly permissible abortion under the existing law. With respect to the moral and theological arguments, I suggest to you that morality and theology are personal matters. I think it is clear to all of us here that what is right or moral for one person or one group of persons is equally not right or not moral to many, many others. I reiterate the fact that a woman whose own moral, religious, or philosophical principles leads her to believe that an abortion is wrong need not nor will she have an abortion. But I believe further that the state has a right to regulate individual behavior and morality only to a certain point and no further. I believe that the state has satisfied its own interest by prescribing reasonable, acceptable indications in sets of circumstances under which an abortion legally may be performed.
1 minute.
Beyond that, and within these prescribed sets of circumstances, it's my belief that the individual must make her own judgment. She must make this decision with herself, her husband, her family, her own doctor, her own friends, whomever else she may rely upon, and her own clergyman. I think the fact that more than 1,200 clergymen of many faiths throughout California have signed their names in support of this bill is an indication that no one point of view is the only acceptable moral or theological point of view. Let me skip some more here and get quickly to the legal points. Mr. Trinkaus contends that a minuscule, several-week-old fetus is the equivalent of a human being. If you agree with him, that's fine. I simply don't. Every case which he can cite as giving a fetus rights involves a fetus that is subsequently born alive, and the section of the Civil Code which he cites ends up in the event of its subsequent birth. These things are relevant only when a person eventually eventuates from what had been simply a fetus.
Time.
I suggest that if this proposed bill is unconstitutional, so is our existing law, where there is no due process given. And I suggest, if I may just take another half minute, Mr. Chairman, that the fact that the American Law Institute is supporting an even stronger approach to this subject, the fact that the deans of virtually every law school in this state are supporting this bill, and that thousands of lawyers throughout this state are supporting the bill, gives some indication that it is not unconstitutional. Thank you very much.
Yeah, a little over 5.
Mr. Beilenson asserted that he was more impressed by moral and theological arguments than legal ones. I think it's fortunate that when we are discussing the due process clause of the 14th Amendment, we are so directly concerned with human rights that we are inevitably concerning ourselves with the morality of the problem. The theology of it is something else. That is something we will leave to the theologians. But we are all concerned with the morality of the problem, and Mr. Beilenson says that it should be the morality, the moral feelings, or the moral beliefs of the mother which would determine whether or not the life of the child is to be taken. I have never, at any time, ever, in all the hearings that I've attended on this subject, heard any person say that he knows as an absolute fact that a child does not become a person from the moment of conception, a human person. Even those who are motivated by the most wishful of wishful thinking have not stated that. Consequently, is it proper, I ask rhetorically, to take the life of someone, of something, when you don't know whether or not it's a human life? I don't think that the feelings of the mother should absolutely control, because we are concerned with the rights of others here, the rights of the child itself. The problem takes on a different stature. Mr. Beilenson, I wish to congratulate him on not overemphasizing the hardship cases, the rape and the incest and all this sort of thing, because they are a very small part of the abortions which would be involved if this bill were enacted. Of the 1 million abortions, illegal abortions each year, it is estimated that up to 90% are on married women. Those abortions are being performed not because of extreme hardship such as rape or incest, but because of convenience. The inconvenience may be a serious one, but it is still something which has to be weighed against the taking of a life. The hospitals, there are over 300 hospitals in California who would be eligible for these committees under his bill. Their standards vary. We have good hospitals, ones with high standards, and we have some with less, smaller proprietary hospitals. And that's particularly true in this area of abortion, because under the present law, the rate of abortions to live births vary in California from 1 in 7,000 to 1 in 120. That is one abortion in 120 live births in one small proprietary hospital not too far from here. So when we liberalize the law over this is under the present law, I'm saying. But if we liberalize that law according to Mr. Beilenson's suggestions, I think we are inviting legalized abortion mills. What would the hospitals who have this rate of 1 to 120 or something like that do if they had the standards of Mr. Beilenson's bill to guide them? The District Attorney of Los Angeles has estimated, or has stated, that the illegal abortions constitute the second largest racket in Los Angeles County. There's a great deal of money involved. And so some of these hospitals, some of the doctors, unfortunately, could be motivated by some reasons of remuneration, thus inviting the legalized abortion mill. Now, I suggest also that when we consider the hardship cases, we have to distinguish between the rights of the individual, the rights of the unborn child, and the culpability of the person who performed the abortion. Certainly, if you take one of these real difficult cases and an abortion is performed, we say, well, it's illegal, but I certainly have some sympathy with the person who was forced into such a difficult decision. But that does not permit us to change our standards of right and wrong. Neither does the fact that there are innumerable violations of the present law excuse a change in the law. There are a million violations of the present law today a year throughout the United States. But I suggest that there are more than 1 million violations of the Ten Commandments every day, but so far as I've heard, they haven't been repealed yet. Now,
1 minute.
I think that Mr. Beilenson would concede that liberal abortion laws aren't going to solve the problem, and the problem is there. There's no question about it. I agree with him on that. The problem's there. But the liberal abortion laws are not going to solve it. But the women who are in these difficult situations do need counseling. They do need help. And the state should provide means of giving that counseling and giving that kind of help, rather than to try to solve the problem which in what appears to be the obvious and easy way, which is to take the life take the life of a person who has the right to the law's protection. Thank you very much.
At this time, there will be a brief intermission for all those who do have to leave for their classes. And for those who will be remaining for the question and answer period, I would ask if you please move forward. Also, I'd like to thank both Mr. Trinkaus and Assemblyman Beilenson for appearing on the speaker's program today. If you'd like, you want to speak into this microphone so everyone else can hear you.
The questions are all related to the question of is the conceived but unborn entity a person? Now, you said from the time of conception, an unborn child has inherent in it all the qualities of a human being. And my first of this related set of questions is that since, and I think you meant, of course, the chromosomal properties and the hereditary properties which allows it to develop into a human being. But since any single cell of the human body, with the exception of sperm cells, have these chromosomal hereditary properties, and in fact, in the not too distant future, will be able to be developed into a human being by biologic processes, my first of these related set would be to ask whether we should take such extreme care and in fact constitutionally safeguard every single cell of every human body. The second of the related set is that since it is true that intrauterine contraceptive devices and also progesterone-inhibitant pill contraceptives and other forms of contraceptives now widely distributed and which are the most effective contraceptives act by aborting, that is to say, they act by preventing nidation, preventing attachment of the already conceived and developing ovum to the wall of the uterus, would you consider that the distribution of these and the use of these to be a felony under the present law, and would you consider this ovum that hasn't yet attached to be a human being?
Thank you.
And the final is what do you say about all the spontaneous abortions and the fact that death certificates, et cetera, are not required in the case of all the spontaneous abortions until something like 7 months?
With regard to the comparison of an embryo with any other cell in the body, I think that there is a valid distinction. Frankly, my knowledge of biology is such that I must depend on asking biologists, and strangely enough, on Life magazine. Possibly you recall this issue some while back where they showed the development of an embryo and a fetus beginning with a few days and going all the way up to 9 months. That, of course, is probably not the best biological authority in the world, but it's interesting, and it was illustrated so I could understand it. At the a few days after conception, and they had a picture of an embryo with had all the beginnings of arms and legs and this and that and the other thing, which would and very shortly after that they became even more noticeable, which leads to an illustration, I think, of what biologists tell me, and that is that at conception, after there's a unification of the sperm and the egg, all of these things are inherent. I'm not talking about the chromosomes of heredity, but the arms and legs and eyes and nose and everything else that a human being has. Now, I don't equate either the act of abortion with contraception, because there has not been a joinder of the sperm and the egg when the contraception occurs. Spontaneous abortions, you say, present a problem to you because they don't always require a death certificate. That's probably true. I don't know. Because they're at a certain stage, it's impractical to do so. But I don't think that the fact that they don't require a death certificate for a spontaneous abortion at an early stage necessarily answers our problem. And particularly that point of mine, which was directed to the fact that no one that I ever heard has yet said that they know that this is not a human life. And it appears to me that the more we do know about it, the more we learn about it, the more human it does become.
Can we get someone else? Are there any other questions? Gentleman with the glasses? And
well, if it is true that a birth control device operates to prevent life or to eliminate life or to kill a life existing after conception, I would say that it would be inconsistent with the abortion laws if that were used deliberately for that purpose to accomplish it in that way. Now, I don't know whether when this device is used it is intended to operate this way or whether it just operates that way from time to time. But I think actually our problem which Mr. Beilenson and I have in arguing about the abortion laws is complicated enough without adding some marginal contraceptive problems along with it.
Gentleman in the brown.
All right, if you're going to be consistent then, if you deliberately use a contraceptive device which is intended to and does kill an embryo, it's abortion.
The gentleman in the brown.
The question was if a mother during a pregnancy abuses herself so as to cause a miscarriage, is that abortion? Is that the substance of it? Well, the law does it right now.
Gentleman in the blue jacket.
gentleman asked, I think, why, since I have no constitutional problem with the rights of an unborn fetus, I don't extend the bill to provide for other instances, specifically unwed mothers or welfare recipients, people of that sort. Of course, you're mentioning only a small number of other possibilities. You could have abortion on demand for any possible reason. I've simply picked out what I think are very extreme and potentially tragic cases, and as you pointed out, that's all that we're asking for here. Basically, I think, because I have a certain responsibility as a lawmaker, and I'm trying to reflect what I think, or what I feel to be, and what I'm now convinced is the majority opinion of the people of the state and probably of the nation as to what the criminal law should be. I think the criminal law should basically reflect the mores and standards and criteria of a society. I think that this bill does. I don't know that a bill which went further would, and therefore I feel better about the whole thing, and I'm convinced within myself that this is a proper thing because we have important other interests to balance, that is the health of the mother or the fact, the possibility that the baby may be born deficient or deformed. I have grave problems with this, as I suppose I intimated before. I happen to care a lot about this little fetus. I don't think he's a human being. I don't get as upset about it as I do with a newly born child, because I simply think they're different kinds of things. But I happen to care a great deal about this. For a non-Catholic, I'm very Catholic in my outlook on this whole problem of abortions. And what we've tried to do here, as you're well aware, is to insist that there are important overriding or counterbalancing interests which have to be taken into account and which under existing law are given no credence and no weight whatsoever.
May I comment briefly on that? I think the question is well taken to this extent, that to be consistent, you either are in favor of abortion or you're against it. Either can be had at will or you can't have it at all, unless it's for reasons proportionate to the act of abortion. And consequently, I think many of those who favor Mr. Beilenson's bill, not Mr. Beilenson himself necessarily, but those who favor his bill, do believe that there should be abortion at will. And so they take kindly to this broad language of the standards in Mr. Beilenson's bill, because they would permit abortions at almost any kind of circumstances, such as mental health. In Scandinavian countries, they have something they call exhaustion neurosis, which permits abortion under this concept of mental health. But I also appreciate Mr. Beilenson's feelings in the matter, where he says he has some feeling for this fetus. But I ask, why? Why does he have any feelings for that fetus? And once that fetus is something which is entitled to anything, which if it has any rights, and the law does recognize that it has rights, then you get into very serious constitutional trouble when you permit abortion through the procedures established here.
If I may comment. As a matter of fact, Mr. Trinkaus, and as you well know, people who are for legalized abortion or for abortion on demand are quite unhappy with me and my bill. They're not happy with it. They don't think it's broad enough, and they don't think it would take care of most of their problems, and they're right. It won't. Now let me ask you a question in terms of consistency. How do you feel about the existing law on abortions in California? You think that's unconstitutional? Do you approve it? Would you support it if it were before us now?
I accept the existing law as being preferable to the one proposed by Mr. Beilenson. I say that also that the existing law as it is not unconstitutional, because it is a penal statute which prohibits abortion unless the abortion is performed to save the life of the mother. Now, there are no procedures at all. There are no protections at all under the present law. And so we don't get into these procedural problems. But where the constitutional problem, which would arise under the format of the present law, is not under the Due Process Clause, but under the Equal Protection Clause of the Constitution. For example, if instead of using Mr. Beilenson's proposed procedure, you just amended the present law and said that one of the exceptions will be, say, statutory rape, then The question would be, is the unborn child given the equal protection of the law? Is that a reasonable exception, statutory rape? I say to protect the life of the mother is a reasonable exception under the equal protection law because it weighs a life against a life.
So I'd solve a lot of constitutional problems with my bill if I had no procedures in it. Is that correct? Just exceptions.
No. All right. As far as the constitutionality of the bill is concerned, that is absolutely true. You would solve some constitutional problems, but I think you would be performing a grave disservice, as I think you yourself recognize, or you wouldn't have put them in there. I said that the present law, as it stands, is constitutional because it's simply a penal statute. But I say that most of the abortions which are performed, many of the abortions which are performed under the present law are not constitutional. And if there was a practicable way of meeting the problem so that the constitutionality of those abortions could be raised in a court of law, I think that an injunction could be obtained against those abortions. Just suppose one of these borderline cases where the mother is distraught and upset, and she goes into the doctor, and the doctor says, well, you're so nervous and upset, I think if you had a child, your health would be endangered to such extent that you might commit suicide, and so your life is in danger. Well, I think if there was anyone to look after the interests of that child, and he went to court and got a guardian for that child, there would be an injunction issued.
Well, I'll get the bill passed and you go get the injunction.
Gentleman with the blue plaid shirt.
That is not true as far as the protection of the life of the person is concerned. The legislators took an oath to conform to the Constitution, that's number one. So they shouldn't deliberately pass what they believe to be an unconstitutional act. I think Mr. Beilenson would agree with that. So I think that the issue of constitutionality is a valid issue to raise in discussing any proposed measure, any proposed law. I think it has been properly raised here and is properly discussed. But I have also noticed this about the constitutional argument: it hasn't been answered on constitutional grounds. It still remains out there. And with your point about liberty, as I understood the point, you said that the 14th Amendment also protects liberties, and therefore the liberties of the mother are being infringed if we don't permit her to have an abortion. Well, of course, that sort of conflict always arises if you prohibit anybody from doing anything. You are infringing on his liberties, and the whole question is whether it's a reasonable and proper infringement or not.
Oh, yeah, one more question.
Not under the procedures which have been suggested by this bill, because the committee is a self-appointed committee by the hospital. There is no representation for the unborn child. The proceedings are secret, and there's no right of appeal or review. Now, I would say that procedurally, a procedure could be established which would conform to the procedural requirements of the 14th Amendment. And I think it would be a desirable thing to do, even under the present law, to have such a procedure established. But, of course, that's only one aspect of the 14th Amendment. There's also the substantive aspect of the Due Process Clause, which requires that the law be reasonable and that a life not be taken for reasons disproportionate to so drastic a remedy.
So even if we had the procedures which you might suggest, and which we might accept, that wouldn't help you at all with supporting this bill, would it? she still has a reasonable problem.
If this bill is ever passed, I hope there are some tightened up procedures in it.
If you'd work more closely with us, we might give more credence to your suggestions.
Well, you get a transcript of what I said today. Maybe it'll help.
Gentlemen.
You mean the federal Constitution would have an abortion amendment in it?
No, I think suppose the Constitution did allow the state
But you mean if the 14th Amendment wasn't there, would I be opposed to it? Yes, I would be opposed to it, even if the 14th Amendment were not a part of the Constitution. Because, as I pointed out, or attempted to point out in my discourse, the discussions of due process go to the very heart of the merits of a case, because you're talking about the rights of persons in its most basic quality. So when you do talk about 14th Amendment and due process and all this sort of thing, you're talking about the merits and even about the morality of the problem, I think.
I'm a Catholic, so I guess by an extension of Mr. Beilenson's argument, I'd have to be very non-Catholic in my opinions, but I think we could have a pretty good discussion about that. Nevertheless, I'd like to direct my question to Mr. Trinkaus, or Trinkaus? Trinkaus. You spent the majority of your time, a large part of your time, debating whether the proposed Beilenson humanitarian abortion law would be constitutional under the 14th Amendment, the Due Process Clause. And you referred to Section 29 of the California Civil Code, I believe, as protecting the rights of unborn children and the hereditary and property rights of unborn children. And I think you'll agree with me that the law protects the moral convictions of the society in which the law governs. And Mr. Beilenson brought to your attention that these laws do state that these protections are available to the unborn children if they are subsequently born. I think that he pretty well, he pretty well brought to your attention that as far as the Section 29 of the California Civil Code, you're incorrect in your legal discussion. Nevertheless, going back to the Due Process Clause in the 14th Amendment, if you do agree with me that the laws reflect the moral convictions of society, you would agree with me that I believe that if the majority of people do agree that a fetus is not a human being per se, and that a born child is a human being per se, and if the Supreme Court, in ruling on Mr. Beilenson's humanitarian abortion law, ruled as such that you would have to agree that since laws do reflect the moral conviction of society, and since the Supreme Court would be in a position of judging on that Mr. Beilenson's proposed law more reflects the moral conviction of our society rather than your rather stodgy reversal back to the common law, I believe. Would you comment on that?
I think if that's a question, I rather admire the form of some of these questions. I think they do a better job than either Mr. Beilenson or I in giving a speech. With regard to Section 29, The speaker pointed out, as Mr. Beilenson did, that Section 29 of the Civil Code recognizes an unborn child as a person for the purpose of protecting its rights in the event of its subsequent birth. With regard to that section, it is protecting rights such, for example, as the right to recover for prenatal injuries, which by their very nature would not be recoverable until the child is born. But that does not say that the law does not protect the child in the protection of its rights, which do not require waiting until birth in order to protect them. For example, I mentioned the case where a guardian was appointed before the child was born to sue its father for support based upon the rights of the unborn child. I also mentioned the case where a guardian was appointed to compel the mother to submit to a blood transfusion in order to protect the life of the child. All those occurred prior to birth and recognize that rights do exist. And the point that I was making, of course, was that if the law protects, or if the law protects rights of a child, if a child does have rights prior to its birth, then the child must have the most basic right, the one that underlies all of them. That's the right to exist. I forgot what the other point was he made. I think you said that Mr. Beilenson's bill conforms more to the mores of society, I suppose, as we are today, and that's what the law is supposed to do, and therefore the old fogies like me, is that what you said, or stodgy, the ones with the stodgy viewpoints that just sit down and keep quiet. I don't think that necessarily follows. What we are debating in part is what is this moral viewpoint of society, and in part I'm trying to persuade you to a viewpoint on this question, and you are a part of society. But more important than that is the fact that what I am basically arguing is the fact that an unborn child has rights, and I don't care what the viewpoint of society is. Once you concede that there is a person with rights to be protected, you can't take them away. And even a majority in Alabama or Mississippi, a vast majority can't take away rights of individuals, regardless of the viewpoint of society in those sections.
We have time for one last question. The last question is from a female. Does the girl need glasses?
I agree with your premise, but not your conclusion. In case everybody couldn't hear it, the question was directed to the fact that the district attorney of Los Angeles has stated that illegal abortions are the second largest racket in the county, and the questioner said, doesn't that indicate that there is a need for revision in the abortion laws so that these women who are going to the illegal abortionist will go to a regular doctor in a recognized hospital and so on? And I say that she's absolutely right about the fact that that problem does exist and that the law should do something about it. And we should make provision for these poor, unfortunate people who are so distraught and disturbed and in such dire circumstances that they resort to the backyard abortionist. But 90% of those people are married women. 90% of those people are women who could just as well have not had an abortion. And it is conceded by all in the hearings which we've had before Mr. Beilenson's committee on this subject, that the medical indications for abortion have practically evaporated with the advancement of medical science. They even changed the name of the law from therapeutic to humane because the law is no longer therapeutic. Consequently, most of these abortions performed on these married women are being performed for socioeconomic reasons. And there again, if we are going to be consistent, we should say, well, if they want an abortion, let them have one because it's inconvenient or it's expensive to have another child and so on. Or recognize the rights of the child. But you can't go halfway in between, because once you recognize that the child has any rights, then you have to give him his right to life.
Thank you. Again, at this time, I'd like to thank both Councilman Beilenson and Mr. Trinkaus for coming here today. Thank you. Go ahead.